this world we're thrown.
Good evening, Noswitha. I do not know whether the Right Trusty and well-beloved Charles James Dalrymple Shaw, commonly called Lord Kilbrandon, was a fan of Jim Morrison and the Doors, although somehow I doubt it. Their music takes us back to a different world. Harold Wilson and Ted Heath, and yes, my bell-bottom trousers, and in particular the Royal Commission on the Constitution, aka the Kilbrandon Commission. Remarkably perhaps, the Commission's report remains, some 40 years later, the last serious attempt by official sources to grapple with the territorial architecture of the Union states in a joined-up way. The Commission had set out in stormy conditions amid an early wave of nationalist sentiment, especially in Scotland. There was obviously, the report solemnly intoned, some discontent with the workings of government. Featuring barons and knights as well as esquires, and yes, one woman, the Commission evidently appeared the very model of a modern, independent, expert body. In the event, the Commission had a bad trip. The instructions were vague, the ride seemingly endless, and as shown in a comprehensive memorandum of dissent, the band fell out. Yet the legacy of Kilbrandon should not be discounted. Famously, the Commission rejected federalism as a possible solution for the UK's apparent constitutional woes, declaring that few of our witnesses advocated it, and people who know the system well tend to advise against it. A slightly surprising conclusion, one might think, given that the rise of the dominions and retreat from empire had seen Britain conjuring federalism for many peoples around the world. In fact, ineffectively burying the federal idea in the UK for a generation or more, Kilbrandon reflected and reinforced the strict conception of a full, formal federal system. Sovereignty divided between two levels of government, a written constitution, basic terms entrenched. The Commission emphasised two objections which continue to resonate today. First, and ahead of much growth in judicial review, excessive legalism, or as might now be said, too much power for the UK Supreme Court in what should essentially be a political constitution. Second, the dominance of England, represented today by 85% of the UK population. Such are the problems of governability or standoffs between the UK Parliament and a putative English one, laced in turn with an evident distaste for a bigger governing class, or divide and rule through English regional assemblies. In merciful release from much mind-numbing detail, Kilbrandon established a small reservoir of general principles for reform of the territorial constitution. Perhaps the better adjective is reinvented, since it doesn't do to overlook all the historical legacy here of the debates over Home Rule in Victorian times and later. Kilbrandon's was the stuff of the need to preserve unity coupled with desirable flexibility, to which had to be added the obvious element of legitimacy. Constitutional arrangements cannot be imposed against the will of the people. And also constitutional fundamentals such as preserving and fostering representative democracy, and, as it would then have been put, the greatest regard for the liberty of the individual. In the bleak midwinter, as he saw it, of the Thatcherite 1980s, a People's Remembrancer famously posed the question, when was Wales? As befits the Marxist historian, Gwynalf Williams was very, very fond of the crisis word. Indeed, his short history of the Welsh includes such headings as crisis of identity, crisis of society, and, oh dear, crisis of survival. Indeed, he speaks at one point of a cycle of terminal crises, and that's only in Roman times. But today, it's surely no exaggeration to think in terms of a territorial constitutional crisis in the United Kingdom, or in the words of the Oxford Dictionary definition, a time of intense difficulty or danger for the Union. The twin political facts that in the Scottish independence referendum, some 45% voted to leave, and that an avowedly separatist party has won victories in a UK general election on a scale not seen since Sinn Féin in 1918, cannot be wished away. Yet what is an ongoing political and constitutional storm, centred at least for the time being on Scotland, provides an opportunity, not just for those who in properly democratic fashion promote the cause of independence, but also for some much-needed modernisation of the UK's territorial constitution and, yes, of the central government machine. Not an Ireland entire of itself, the stakes could hardly be higher for Wales. It cannot simply be a case of free riding. Gwynalf Williams did not live to see the devolutionary answer that Wales is now. What an extraordinary constitutional journey it has been. Triggered narrowly by referendum and inaugurated under the Government of Wales Act 1998, the first executive phase of Welsh devolution gave birth to a recognisably national polity. Developed via Part 3 of the Government of Wales Act 2006, a second proto-legislative phase established a mainstream structure of parliamentary government. Activated under Part 4 of the same Act by convincing majority in a referendum, a third fully legislative phase continues with an intricate model of conferred powers. The Wales Act 2014 has also broken new ground in the fiscal constitution by establishing some Welsh taxing powers. Successive bouts of public criticism, followed by review and recommendation by Independent Commission, Richard, Jones-Parry, Holtham, Silk 1 and 2, underwrite the mantra that devolution is a process, not an event. The scale of the Welsh homegrown autochthonous development should not be overlooked, however. Future historians will surely remark on a whole series of domestic building blocks. For example, major internal reform of organisational structures or innovative provision in such areas as sustainable development, equality and bilingualism. This aspect deserves special emphasis in view of a surrounding territorial constitutional turmoil, which has, after all, been brewing for quite some time. To adapt one of Gwynalf's better-known aphorisms, Wales is an artifact which the Welsh partially produce, if they want to. Naturally, as an academic, I believe that the quality of the product needs careful testing, including these days in terms of impact. Published in 2003, my original monograph on Welsh devolution was a public lawyer's response to Gwynalf's celebrated question. It examined the early processes of establishing legal and political responsibilities, the creation of often skeletal institutional forms, the new relations with local government and public agencies, and the beginnings of post-devolution networks in civil society under the title Delineating Wales. With benchmarks thus to hand, it will soon be time properly to evaluate the internal maturation of the Welsh polity across the different phases under the fuller rubric of constituting Wales. It would be a shameful abuse of hospitality if at this point I did not mention the UK Changing Constitution project, an intellectual front no less for the Wales Governance Centre and others. Running for 3 years from 2012, the project has served to enrich our understanding of territorial politics, not least through partnership working across Offa's Dyke. and made an important series of targeted interventions in the Welsh devolutionary process. For present purposes, the fact of the project underscores several key themes. The pervasive sense of ferment in a territorial constitution, the need for more considered responses than those hitherto on offer from the UK government, and the insufficiently well-known fact of Wales as a small but significant crucible of innovative constitutional thinking about the Union. For the avoidance of doubt, I do not suggest that Wales has somehow had a monopoly on futuristic constitutional theory about the fundamentals of the distribution of powers and resources across the 4 home countries and the relations between them, inside the Union state. Indeed, in the terms of my title, there is today a whole cottage industry of unofficial responses to territorial constitutional crisis, all those think tanks and lobby groups. Putting this in perspective, ad hoc and piecemeal is a familiar concern with UK constitutional development and with the development of the territorial constitution in particular. Nor have 15 years of experience with asymmetrical devolution served to blunt the criticism. In light of a rapid and ongoing redistribution of lawmaking and governmental powers to different parts of the Union, quite the reverse. The House of Lords Constitution Committee castigates the Unionist parties at Westminster for no coherent vision for the future shape of the UK, and expresses astonishment, no less, at Whitehall's seeming failure to think through the wider implications of further powers for Scotland. In fact, conditions have been ripe in Wales for a more considered approach. It is not simply that in the last few years Wales has had the only devolved government wholly committed to the Union. For this junior member of the family of countries, muddling through the territorial constitution commonly has negative connotations. More exchanges between Westminster and Holyrood, less in the title of the original devolution white paper, A Voice for Wales. As First Minister, Cowan Jones has set about articulating a new union mindset that speaks to a looser and less hierarchical set of constitutional arrangements in which several systems of parliamentary government are grounded in popular sovereignty and cooperate for mutual benefit. Viewed in comparative perspective, this is the realm of asymmetrical quasi-federalism, an ugly phrase which serves nonetheless to combine 2 creative elements of constitutional theory. On the one hand, the scope with distributed authority for territorial variation around a strong common core in the light of particular historic, demographic and economic factors, an aspect, it can safely be said, which has special resonance in Wales. On the other hand, moving beyond the strict conception of federalism shot down by Kilbrandon, the broader reach of federal-type ideas of self-rule and shared rule in a flexible system of multi-level governance, where the First Minister has identified enabling unity while guaranteeing diversity as, and I quote, exactly the challenge we face. Future historians will no doubt wish to reflect on how these high-level statements have played out in the Welsh Government's evolving constitutional policy. Some may even be a little critical of this brand of new union thinking for insufficient attention to localism within each nation. Several positive aspects of the new union mindset deserve special emphasis. In terms of the general direction of travel, the approach reflects and reinforces the growth of federal-type elements in the UK Constitution, epitomised today in moves statutorily to recognise the Scottish and Welsh devolved institutions as permanent features on the constitutional landscape. Second, mutual respect between the different legislatures inside the UK is a cardinal principle. The routine workings of Dicey's doctrine of parliamentary sovereignty may suffice in England, but unless with the explicit assent of the devolved legislature, Westminster should not, on a suitably generous reading of the well-known Sewell Convention, legislate with regard to devolved matters or competence. Splendidly envisaged, this involves the abandonment of Anglo-centric and metropolitan practices of what I have elsewhere called constitutional patriarchy. Thirdly, a holistic view of the character and purposes of the Union is of the essence of this approach. Drawing, for example, on the admirably accessible analysis of the 2009 Kalman report on Scottish devolution, attention is here drawn to the triple alliance of political union, as with representation of all parts of the centre, economic union, as with an integrated market underpinned by a single currency and central fiscal framework, and social union, as with a safety net of welfare benefits, to which must, of course, be added security and defence union. As one would expect from a Welsh Labour leader, the First Minister has placed particular stress on social solidarity, howsoever fragmented in recent times, and hence the need to preserve basic entitlements as a core component of common citizenship. Happily, in the interests of political balance, and particularly happily because of his introduction, I can refer to the work of Deputy Presiding Officer in the National Assembly and Conservative AM, David Melding, who has sketched an alternative vision of a reformed union. The working assumption is that without a firm constitutional settlement, as in the form of a new Act of Union, unionism is destined to fail. Good Tory stuff on no clean break, this grounds the idea of a federation deeply infused with something called the British parliamentary tradition. Notably, one thing on which our protagonists have agreed is the importance of constitutional timing and process. From 2012 on, the First Minister repeatedly called for a constitutional convention jointly sponsored by all four governments in the UK, in part to allow public participation, but in particular to facilitate joined-up thinking on the territorial constitution, rather than conversations in different rooms or bilateral reforms to particular constitutional arrangements, and further, of course, to ensure a seat for Wales at the table. This was coupled with clear warnings to the then Cameron-Clegg government: be proactive or risk being dictated to by events in North Britain. Nor could the Deputy Presiding Officer fairly be accused of constitutional shyness when messaging his Conservative colleagues in coalition in London. Such was the rhetoric in hammering home the need for a constitutional convention, of Britain only surviving with a quick rewrite of the constitutional rulebook. However, these local soothsayers were fated to go unheeded in Whitehall in the critical period ahead of the Scottish independence referendum. Such, it may be said, is the condition of Wales. The Cameron-Clegg administration I recently wrote will go down in history as the government which almost lost the Union. Permitted under the terms of the so-called Edinburgh Agreement, a fine example of popular Scottish sovereignty had brought a complacent and then panicked Westminster elite virtually to its knees. If not the end, then strange days when, at the thunderous height of an energising referendum campaign, the leaders of the main unionist parties suddenly vow major constitutional reform, Devo more, or faster, safer and better change for Scotland, in the Daily Record. Among many noises off, the Smith Commission was conjured into existence, tasked with making recommendations for further devolution of powers to the Scottish Parliament. As what in the Academy we like to call a constitutional moment, September 2014 and all its works take some beating. Future historians will no doubt be busy tracing the relevant changes in the constitutional weather. Attention is inevitably drawn to two particular sets of developments. the first one being the work of the Smith Commission and underwriting the huge political stakes, an almost mechanical rendition of their proposals, item by item, in a command paper most hopefully titled Scotland in the United Kingdom, an Enduring Settlement. The process is an exemplar, on the one hand, of cross-party discussions with an independent chairman and tight timetable, hence scarce public involvement, many rough edges, but a deal nonetheless. And on the other, of what has so concerned the Welsh First Minister, hence discrete territorial and union focus and likely knock-on effects for the rest of the UK. Then again, in light of the several major pillars of institutional, tax and welfare reform in the Smith Report, certain bits, for example on the permanency of devolved institutions, could cheerfully, croeso I Gymru, be read across. The Prime Minister's immediate and very public linking of more powers for Scotland with something called a fair settlement for England will also linger long in constitutional memory. For the rigidly devout unionist, EVEL, English votes for English laws, should be anathema. But in terms of political representation at the centre, this, it seems, is a constitutionally more secular age. Illuminating a strong sense of dissatisfaction with how England is currently governed, the leading attitudinal survey suggests considerable public support for this type of approach. Faced by parties strong in the Celtic lands and by the populist challenge of UKIP, it was only too tempting for the Conservatives to push beyond the cautious recommendations of the independent Mackay Commission, so opting for a stronger veto for English MPs on so-called English legislation. Jumping forward to the fact of a Conservative majority government, another source of conflict in the struggle for the Union is identified. The SNP, after all, unlike Sinn Féin, has not yet anyway adopted a general policy of abstentionism at Westminster. Meanwhile, English and Welsh MPs will often be counted together by reason of the historic functional motif of England and Wales in areas such as courts and policing and criminal justice and prisons, but with significantly less representation from Wales in view of the now looming review of UK constituency boundaries. A nice study in political contingency to come. Could this just possibly serve in the medium term to underwrite the case for devolution to Wales in those areas? Expanding the constitutional perspective, the judicial contribution must be factored in, especially with an eye to the future. A substantial devolution case law had already emerged ahead of the Scottish independence referendum, including latterly from Wales in intergovernmental litigation on the intricacies of the conferred powers models, the local government bylaws and the agricultural sector cases. Many of the cases, in fact, involve the doubled protection of human rights with devolution, whereby, alongside the general operation of the Human Rights Act 1998, the Convention rights are part and parcel of the statutory written constitutions of the three Celtic lands. Even discounting for the importance of context, however, the jurisprudence is characterized by a variety of approaches. Whereas some judges downplay the constitutional significance of devolution, hence envisaging strict constraints on the young representative institutions, other judges reflect and reinforce the idea of a new and generous constitutional dispensation, to the extent with Northern Ireland of effectively keeping the show on the road, while other judges again have pursued a more or less middling path. A case law which the Bingham Centre for the Rule of Law has recently suggested, quote, has not been entirely consistent, unquote, is to me more like a morass. Originally argued in May 2014, but with the decision only handed down in February 2015, the asbestosis diseases case showcases, if that is the right word, serious judicial disagreement, or in the terms of this lecture, the lack of a clear judicial response in conditions of territorial constitutional crisis. Naturally a sore point in Cardiff Bay, the Supreme Court not only ruled unanimously against the Assembly's bill on the recovery from employers and insurers of NHS treatment costs on a narrow ground of retrospectivity, but also divided 3-2 against the legislature on the chief issues of vires in the sense of conferred power and compatibility with the fundamental convention right to peaceful enjoyment of possessions. The different approaches in the case on the compatibility issue, or more precisely the question of the proportionality or otherwise of the Assembly's intervention under the rubric of public interest, and hence of the degree of deference or respect or weight given by our judges to an exercise of legislative choice, goes directly to the constitutional status of the several parliaments and assemblies inside the UK. The first approach is elaborated in the minority judgment of Lord Thomas of Cwmgydd, and there combined with a strong defence of democratic legislative space. It is determinedly non-hierarchical in character. This is the stuff of each parliament or assembly being entitled to form its own judgment about public interest. No logical justification for treating the views of one such body in a different way to the others. Great weight attached to the legislative choice made by the Welsh Assembly. Reverting to the fact of Wales as a crucible of innovative constitutional thinking, this fits nicely with the First Minister's New Union mindset, greater parity of esteem across the several democratically legitimated centres of authority inside the UK. The alternative approach appears in the majority judgment of Lord Mance, coupled with the according of weight, not great weight, to the Assembly's legislative choice. Referencing Article 9 of the Bill of Rights, parliamentary privilege and all of that, Lord Mance suggests, and I quote, a relevant distinction between cases concerning primary legislation by the United Kingdom Parliament and other legislative and executive decisions. For which read, cutting to the chase, greater judicial respect for legislation affecting England and little differentiation between the devolved legislatures and other public bodies such as local authorities. Going directly against the constitutional direction of travel, not least in Scotland, this is a backward-looking approach in more ways than one. As such, I think it constitutionally myopic and, yes, unionist folly. In his foreword to the command paper Powers for a Purpose towards a lasting devolution settlement for Wales, published in February 2015, the Secretary of State Stephen Crabb was suitably forthright. It is in the best interests of the people of Wales that we have a clear devolution settlement which gives them a stronger voice over their own affairs within a strong and successful United Kingdom. Begun just 4 months earlier, the cross-party St David's Day process led by the Minister had produced consensus on a list of reforms for a Wales bill that, subsequently advertised in the various election manifestos, was duly promised in draft form in the 2015 Queen's Speech. It does not do, however, to gloss over the differences with the Smith Commission process. The Welsh parties were working first and foremost inside the parameters of the recommendations for further legislative powers for the Assembly made by the Independent Silk Commission. In turn, far from constructing heads of agreement, as did the Smith Commission, they engaged in multiple cherry-picking, with consensus or veto or no time to discuss, then box-ticked. The Welsh process was also parasitical on the Smith Commission, focusing in particular on which of their non-fiscal proposals might be appropriate for Wales. One happily righteous example is devolved competence over Assembly elections with the safeguard of supermajority decision-making. The Welsh process was even more closeted than the Scottish one. Unlike the Smith Commission, there were no appointed members, no website, and no published evidence from the political parties or anyone else. Yes, the Silk Commission had done all this previously, but in an ever more febrile atmosphere ahead of the UK general election, who now was blocking what and why? Lacking in the good governance values of transparency, inclusiveness, and accountability, of which so much has been heard with devolution, the St David's Day process was never likely to produce a lasting settlement for Wales, nor has it. Turning first to fiscal reform, the usual suspects in Welsh devolution of step by step and read across brackets and Scotland close brackets further inform the St David's Day process. But also lurking in the devolutionary shadows is a dynamic which typically goes unremarked, but which could in time have particular relevance for Wales. Namely, that some have powers thrust upon them. Let us consider the convoluted process. Following in the footsteps of the Scotland Act 2012, the Wales Act 2014 sets in train a process whereby the Assembly has responsibility for 10% of all taxes collected in Wales and, subject as the legislation currently stands to a referendum, for some income tax powers. Block grant from the Treasury, however, is still to be determined via the famous Barnett formula, which, equally notoriously, has operated to Wales' disadvantage. The vow to the people of Scotland has suddenly underwritten the place of the Barnett formula in the fiscal constitution. Bilateral, back of the envelope, and lopsided policy making to a T. The St David's Day process, in turn, has the UK government agreeing to introduce a funding floor, so regulating the Barnett-style convergence of Treasury funding per head in Wales to the lower average for England, in, quote, the expectation, unquote, whatever that means, that the Welsh government will call the referendum on income tax powers by 2020. But with the command paper also explaining that the precise level of the floor and the mechanism to deliver it will only be agreed alongside the next UK spending review, the First Minister is seen to be notably cautious about taking on more fiscal powers for the Assembly. Putting this in broader constitutional perspective, a clear framework of relative needs assessment grounded in objective indicators is today nothing less than an article of faith in the Welsh polity. Good governance values of transparency and legitimacy point firmly in this direction. Indeed, with a view to establishing properly independent institutional machinery, HM Treasury might usefully reflect not only on comparative Commonwealth developments, but also valuable precedents at home, such as the Bank of England's Monetary Policy Committee and the Office for Budget Responsibility. All the more so, it might be said, in light of the First Minister's evident concern, given the clear constitutional merits of devolved fiscal powers in terms both of responsive policy levers and local lines of democratic accountability. Wales, meanwhile, is seemingly embarking on a fourth revamped legislative phase, with the move to a reserved powers model being virtually a given in the St David's Day process. I've long been a proponent of this type of arrangement for the kinds of reasons articulated in the 2014 report from the Commission on Devolution in Wales, aka SILT 2. Most notably, the linked potentials of greater clarity and consistency, enhanced policy space in Cardiff Bay, and sharper lines of political accountability. However, a key theme of my evidence all those years ago to the Richard Commission was that model and powers go together, the evident advantages of the one being largely dependent in practice on the scale and design of the other. At the heart of day-to-day issues of legislative competence is what I call the connector term. To be precise, the statutory formula relates to. As the shared talisman of different models of devolution, the connector in fact works in opposite ways. So referencing on the one hand the requirement with conferred powers to find relevant statutory pegs on which to hang policies, and on the other, the need with reserved powers to avoid a whole set of legislative hooks. The reverse dynamics become even clearer if one imagines an alternative connector term, falls within. From the standpoint of the Welsh Government, this would be very restrictive with a conferred powers model, but conversely, highly liberating with a reserved powers model, which in parentheses is why it is most unlikely to happen. The burgeoning devolution case law must here be factored into the equation. From the standpoint of the Welsh Government, the Supreme Court ruling in the agricultural sector case that Assembly legislation, where it also relates to a subject on which the conferred powers model is silent, is within powers if it, and I quote, fairly and realistically, unquote, relates to a subject of devolved competence, was, dare one say it, a green light. The First Minister was duly happy. However, serving to point up the potential with the move to reserve powers for the rollback of devolved competence, inadvertently or otherwise, a very different spin is detected at Westminster. To quote from a briefing paper for MPs, the judgment, quote, made it clear that the current model might confer considerably wider powers than the UK government had intended in the 2006 Act, unquote. As an exercise in narrow interpretation, the majority judgment on devolved competence in the asbestosis diseases case sends the message, proceed with caution. Lord Mance was following precedent in reading across from Scotland, where it duly underwrites the more generous devolutionary framework, the reading of relates to as demanding, quote, more than a loose or consequential connection. But in working with this in formulaic and private law fashion, to read down the statutory language of devolved competence in the 2006 Act, his judgment underscores the strict constraints of the conferred powers model. Indeed, in suitably paradoxical fashion, his approach has given the local demand for reserved powers a push start. Constructing a reserved powers model for a small polity, long dependent on and socially and economically integrated with its larger English neighbour, was always going to be very challenging. And the more so, of course, in view of the constitutionally unique and ever more awkward situation of two legislatures, Cardiff Bay and Westminster, and one legal system, England and Wales. Turning this round, the putative move to reserve powers may well, in the not-so-long view, herald a fifth legal jurisdictional phase of Welsh devolution, as indeed Silk II envisaged. For those labouring mightily behind the scenes in the cause of the Red Dragon, retirement is scarcely an option. The St. David's Day process has, however, compounded the drafting problems. Such is the remorseless logic of a situation in which Silk II sensibly combines the reserve powers model approach with a substantial set of proposals for further devolution, not least in policing, prisons, and criminal justice. But then substantial parts of these are vetoed, in particular, much of anything to do with the Home Office. The annexes to the command paper are instructive. One provides an illustrative list, quote unquote, showing the UK government's original thinking on where reservations would be needed. The list speaks volumes, literally. for which read not only things like civil law and procedure and criminal law and procedure no less, but also a paradigm field for multifaceted policy development like prevention of crime. A second annex gives a page-long example of a set of reservations in a single field, road transport. Even this is deceptively simple, illustrating none of the exceptions, let alone carve-outs from those exceptions, liable to mark assembly competence over particular aspects of different policy fields. Grimly familiar in Wales from legislative competence orders, elemental rule of law concerns about clarity and transparency in the constitutional order ought not to be glossed over. A third annex, which contains a checklist of matters for consideration when preparing a reserve powers model for Wales, is highly London-centric. While the pull of UK-wide policy delivery to ensure that citizens have the same rights and obligations is properly highlighted, nowhere is this matched with the devolutionary principles of subsidiarity, autonomy, and diversity. In speaking of silent subjects considered the sole responsibility of Westminster, the guidance also signals some striking back at the judicial reasoning in agricultural wages. The First Minister, in a speech in London just a few days ago, made clear his serious misgivings, to the extent of an implicit threat that if the reservation making gets out of hand, the Welsh Government might not advise the Assembly to give its legislative consent, an attempt at a veritable territorial veto. Be this as it may, it would be a most pleasant surprise if the draft legislative framework measures up to the admirable sentiments of the Secretary of State in Powers for a Purpose, where he spoke of the path to a clear, robust, and lasting devolution settlement. As things stand, the spectre looms of a strange constitutional beast, very different from, say, the Scotland Act 1998, where the lists of reservations were, of course, combined with the many animating provisions for a parliament and government. Contemplate, then, the possibility of this: some short legislative parts concerning permanence and powers that flow from the St. David's Day process, coupled no doubt with some distractive power to adjust competencies, followed by page after page after page of what the devolved institutions cannot do. The Wales Act, a contradiction in terms, it would be a cruel fate. To the victor go the spoils. The predictable response from the leader of a majority government freshly contemplating years of power under the Fixed-Term Parliaments Act 2011, David Cameron has been very quick to rule out the possible froth of a constitutional convention, or what he caricatured as an enormous talking shop with every faddish idea under the sun. Signalling a busy session at Westminster, the 2015 Queen's Speech features a great weight of constitutional legislation, which is heavily targeted on the territorial architecture of the state, so reflecting and reinforcing the pervasive sense of a crisis. A Scotland bill published immediately, of course, to implement the Smith Commission proposals. The draft Wales bill, not yet published for reasons already indicated, but founding the expectation of a statute in the next session. A Northern Ireland Stormont House Agreement Bill, establishing a historical investigations unit, which it is hoped, all fingers and toes crossed, will again keep that particular show on the road. Meanwhile, for England, a cities and local government devolution bill, which, if in somewhat half-hearted and inevitably patchwork fashion, grapples with the internal governance aspect of the dreaded English question. Not forgetting the victor's touch of evil, where changes to standing orders provide a protectively domestic way forward. Notably, an accompanying piece of constitutional cut and paste from the Prime Minister's office evidences concern for at least a veneer of coherence. Oh, so one nation, each and every part of this legislative tour of the 4 home countries is thus assigned the same purpose: to ensure, wherever you live in the United Kingdom, that you have a government that is on your side and represents your interests. This may just have the local Marxist historian turning in his grave. But of course, the May 2015 general election produced 2 winners. Not just the Prime Minister with the blue sash, but also Nicola Sturgeon with the yellow one. Who will best traverse the constitutional moment? Who indeed will most whip things up? Alternatively, can David Cameron and his successors ride out the storm? And indeed, how intense for Wales and the rest of the UK will be the buffeting side winds? Certainly it does not detract from the sense of crisis for the Union, quite the reverse, to point up the chief element of gradualism in the SNP's approach, more particularly post-referendum. We believe in independence, but that is not what this election is about. As a form of political enticement directed to an end to austerity, and more particularly to collapsing the Unionist Scottish Labour Party like a house of cards, the language of their May 2015 manifesto could not have been bettered. Let me refer to a report published in April by UCL's Constitution Unit, which usefully synthesises much in a public discussion apt to be weighed down in detail. A set of maps of possible constitutional ways forward is provided, in which Scotland naturally features prominently. It is for our Celtic, or should that be Celtic cousins, the ever more familiar 3 models picture: Devo More, by which is meant the substantial Smith package already in train; Devo Even More, for which reads Smith plus extras such as business taxes, employment law and certain other welfare powers; and Devo Max, the SNP-style iteration of, on the one hand, full fiscal autonomy, and on the other, a most basic union core, perhaps monetary policy, foreign policy, defence and security, citizenship, VAT. Underwriting the pace of events, perhaps it was inevitable that Devo Even More would be a topic of conversation between David Cameron and Nicola Sturgeon within days of the May election. Self-evidently, the further one goes down the path of Devo Even More, the greater is the challenge to social citizenship as a means of pooling and redistributing risks and resources. Even, however, with a different constellation of political forces, the constitutional conversation in this area is apt to be a continuing one. Successive generations of the welfare state teach that patterns of entitlement are hardly fixed in stone. The scope for legislative and executive dialogue is already attested with the Scottish draft clauses, a committee at Holyrood conducting an excellent forensic examination, and in response top-up welfare powers for the Scottish Parliament in the newly published Scotland Bill. Constitutional asymmetry revved up, suffice it to add that from a Welsh perspective, there is a certain dreamlike quality to this development in light of the differential funding levels. A cautious approach on the part of the Welsh Government to the gaining of welfare powers, especially top-up ones, is thus readily envisaged. Legal authority without the financial resources properly to animate it is not a good place to be in terms of constitutional and political responsibility. A somewhat elastic term, Devo Max was subtly repackaged in the SNP's 2015 manifesto as, quote, full fiscal responsibility. Yet this confederal-type approach could hardly escape a torrent of criticism concerning possible large-scale adverse effects on the public finances in Scotland, and hence for many citizens for whom good unionists should also have a care, especially in the light of weakening oil revenues. But further, there are fundamental constitutional points to be made about a policy which amounts to a poison pill for the Union. For example, on the economic side, it raises an Athenian-type question of why all we taxpayers would continue to bear the risks of currency and monetary policy if Union institutions lack effective control of fiscal policy in the member part. Or again, the social union would appear but a hollow hope should its institutions be unable to proceed on the basis that poverty neither begins nor ends at Gretna Green. Looking forward, it is not difficult to identify a useful set of institutional reforms in London. In truth, however, this is because, in the face of Whitehall and Westminster conservatism, they have been knocking around for quite some time. Take one of the better ideas in Labour's May 2015 manifesto, a Senate of the nations and regions. This obviously is no magic anchor to secure the Union, though it might just help a bit. But in constituting a set of voices from across the UK, it is, as against a House of Lords disproportionately composed from certain parts of London, a good constitutional way to go. Again, take the argument recently rehearsed in evidence to the House of Lords Constitution Committee for a single territorial Secretary of State. By reason not only of the growth of devolved powers, but also of the urgent need for joined-up constitutional policy in London, this becomes a more compelling idea by the day. Further, an old hobby horse of mine is the importance of comity, trust and fair dealing among the governments within the United Kingdom. Some encouraging noises are made in the so-called concordats, the myriad official documentation on principles, structures and processes first agreed by the four governments in 1999 with a view to constructive, efficient and effective forms of intergovernmental relations. As well as providing for political machinery, most notably the Joint Ministerial Committee, the principal Memorandum of Understanding thus highlights cooperation and consultation, as well as coordination, as basic desiderata. Looking forward, Whitehall will have heightened responsibility for upholding such precepts in a looser form of union characterised by more exclusive territorial authority and much shared interest. Perhaps, hopefully, a reference in the Queen's Speech documentation to working with the devolved governments on a revised MOU will lead to concerns about very variable practices, lack of transparency, and organisational skews in favour of Whitehall finally being addressed. A targeted injection of law to underpin the JMC structures would be the next step. But what, it may be asked, are the fully formed F word? I am among those who adhere to Kilbrandon's view that a federal system, strictly conceived, breaks down on the Rock of England. And I also cannot help but feel that much of the historically enticing ambiguity of full-form federalism has now been lost amid the storm. These days, this idea of full-form federalism, this is very much presented as the last best hope for the Union. This is no idle point. Allow me to share a dynamic from a recent full-day seminar at Edinburgh University titled How Federal is Britain? Conducted under the Chatham House rule, this brought together not only academics, but also a swathe of officials and other influential actors from north of the border. Intellectual origins, comparative perspectives, even a few practical pointers, it all proceeded swimmingly until someone, I wonder who, asked why the Scottish government would now be interested in discussing full-form federalism. Answer came there none. And this was even before the results of the May 2015 general election. And let us suppose that somehow, putting to one side the doctrine of parliamentary sovereignty, the UK government started down this path. A secession clause, building on the precedent of the existing border poll provisions for Northern Ireland, would have to be centre stage in the design. To this effect, the very fact of the Scottish independence referendum reflects and reinforces a contemporary constitutional understanding that the UK is a voluntary association of nations, with each entitled to opt out if it so wishes. In the light of statements about the September 2014 vote being a once-in-a-generation opportunity, the debate in Scotland over when it would be reasonable to hold another independence referendum will no doubt continue. But turning the argument round, the UK government did not claim that September 2014 was an opportunity for independence never to be repeated, and thankfully so, in view of the powerful Scots tradition of popular sovereignty. Rehearsing the need for a more rounded approach to the territorial constitution, the Bingham Centre has now made the innovative proposal of a statutory charter of the Union, not unlike, one might suggest, David Melding's earlier ideas. Unfortunately, in my view, their report immediately links this to the rambling question of a written constitution. There is, too, a keep calm and carry on argument for using more neutral language, as with the Constitutional Renewal Act. However this may be, the Charter is presented as a vehicle for what are called principles of union constitutionalism, which, ranging considerably beyond Kilbrandon's old specification, extend to matters such as social solidarity and a common economic framework. Such principles could have a useful role to play in guiding legislative and executive processes at UK level. But I am less enthused about making such principles justiciable as statutory principles of interpretation, hence further invading the political space as the Bingham Centre particularly advocates. Even, that is, if the continuing absurdity and thoroughgoing constitutional slight of no designated Welsh seat on the UK Supreme Court is corrected. Indeed, if UK ministers were tempted to go down the route of justiciability, I would be more interested in interpretative principles bringing a modicum of order to the devolution case law. Happily, the Bingham Centre has already done much of the heavy lifting, with an excellent analysis distilling principles from the jurisprudence, or more accurately, selectively identifying them from the more liberal parts. A system of government for the UK that is coherent, stable and workable, generous grants of devolved legislative authority, a quartet of parliaments and assemblies that enjoy plenary lawmaking powers. As principled guidance for determining issues of devolved authority, this is good to go. Looking forward, Conservative Party policies on an in-out EU referendum and on replacing the much-maligned Human Rights Act with the British Bill of Rights and Responsibilities loom large. A tale of two unions, or the next fork in the road, the constitutional choreography with the EU referendum can already be sketched. The SNP demands a double lock, actually a quadruple lock, whereby the UK remains a member state unless each home country votes to leave. The Conservatives duly insist that no, this is an archetypal UK issue. If, as just could possibly happen, the UK votes to separate, but Scotland votes better together in the EU, the SNP demand another independence referendum, this time making the fair constitutional point of materially different conditions for September 2014. Meanwhile, Wales looks on, possibly transfixed. As for human rights reform, the Conservatives' original policy document talks somewhat darkly of working with the devolved institutions, quote, as necessary, unquote, in order to ensure an effective new settlement across the UK. We touch here on some highly convoluted issues of constitutional and international law, rendered more difficult by the absence of precise legislative proposals in the light of newfound ministerial interest in public consultation. Matters are compounded by fundamental differences between the various devolutionary frameworks. The Good Friday Agreement stipulating incorporation of the European Convention on Human Rights in Northern Ireland. The Scottish Parliament, under their reserved powers model, seemingly able to legislate on human rights, but not to modify the Human Rights Act. And Cardiff Bay, heavily constrained in key intersecting policy areas or by reason of the unified legal system of England and Wales. Tucking in behind Scottish institutions firmly committed to convention rights and making great play with the Sewell Convention could well have major attractions for local ministers and officials. Whitehall would do well in a situation infused with territorial constitutional values to beware stormy weather in prospect. In the continuing struggle for the Union, some battlefields are more promising than others. A case like asbestosis diseases cannot obscure the place of convention rights as part of these progressive young polities' DNA. To conclude, we are not yet at the end of the Union, nor are we in Churchillian terms at the end of the beginning. The question rather which faces us is whether this is the beginning of the end for the Union, and no one knows the answer to that. Self-evidently, however, the chances are much increased. Moods change, but at least for the time being, the wind is in the north. Several things can be said with confidence. First, from the Welsh perspective, this small polity is still being, all too often, buffeted about. The price of devolution, the St. David's Day process reminds us, is eternal vigilance. So for starters, let multiple voices say it loud and clear. The approach to reserved powers currently signalled is the type of arrant pedantry up with which Wales will not put. Secondly, the failure to heed our Welsh soothsayers and take seriously the need for a widely informed and rounded approach to the UK's territorial constitution ahead of the Scottish independence referendum is a big blot on the record of the Cameron-Clegg coalition government. The car crash that was Kilbrandon warns against any easy assumption that a more stable and coherent system of governance would have resulted, not least for England. But from a unionist perspective, just about anything would have been preferable to the storm force circumstances of the vow. As such, I see no reason why it should ever be forgot. Thirdly, if the Union is to survive, this will require political skills and statesmanship of a very high order, especially now to make up lost ground. I've drawn attention here to the place for constructive, federal-type responses at UK level inside a famously uncodified constitution. For without a strong dose of joined-up constitutional thinking at Westminster, and further major changes in the structures and practices of the post-imperial Whitehall machine, the next period of our constitutional futures in this cluttered isle is most likely to prove, well, manic. Thank you. Diolch. Cue the music.